All right, good evening, everyone. Good evening. Sorry for the little delay. Good evening. Can we all hear me? Good
Yes, we
evening.
can hear you.
All right. Thank you very much, Hannah. Good evening to everyone. Thank you so much for joining in. All right. I can see we have a few people on call. So you're welcome to today's session. We're in week 4. We've come so far in our mentorship program, and it's just, how would I say now? It's just been exciting, so much excitement so far. From coming from week 1, where we did the introduction to ADR, then we moved to what mediation is all about, mediation and career opportunities. In week 3, discussed about we discussed about arbitration and career opportunities in arbitration. Now we are taking it a little further, and we want to delve into um, practicals, yeah, because we believe that the sessions in themselves are not supposed to just be theoretical, but then you should see or have a taste of what the practical of how a mediation session should actually look like, right? And I'm sure with some of the research that you guys have done, we'll be able to have a smooth transition, and our mentors will be on call to help us. Will be on call to help us run through what we expect from a mediation simulation and give us advice on where we may have been getting, or we might have gotten some of our, sorry about that, some of the mistakes we have made while preparing for this class. Some of the mistakes we might have made in preparing. Our mentors will be helping us run through them and just setting the pace and taking us through today's class. Sorry, I've been speaking too long. All right, my name is Dennis Williams, and I'll be your moderator for today. Once again, you're welcome to today's session. And not to waste any time, so there's an announcement I would like to make. Please, can someone still confirm that I'm being heard?
Yes, I can hear you.
All right, thank you very much. Yes, so moving on, right? So we recently started announcing about the JIIPCC. The JIIPCC Academy is holding free legal clinic for creatives, entertainers, athletes, innovators, and startups. So yeah, we came up with an initiative last, I think, early this year. Yeah, sometime within the year, to do free pro bono sessions for those who are looking for legal advice. I may not necessarily be able to have access to that within the moment. JIIPCC is offering a 20 minutes consultation with our professionals. So we have a group of professionals who are willing to give professional legal advice as tied to a variety of cases that you or maybe people that may have issues with. So we're using this platform to just appeal to you that if you have anyone who is in need of free legal counsel, right? They can kindly reach out to us. You can kindly reach out to us and register, and we'll do well to fix a date for you to have a 20 minutes consultation with our professionals. So, like I said, this is something new from us, and we are just doing it in the spirit of trying to to give back to the society, give back to people, right? So moving on for what we have today. So we are expecting, like as usual, our mentors, right? The mentors that we are supposed to have in this session. Firstly, we are expecting Mr. Tohid Amuda. We got to hear from Mr. Tohid in the last class. Did a lot in saying he did a lot in explanations and just generally talking about arbitration in the last class, and we expect that by God's grace, we'll be having him again in the session. So just to quickly read through Mr. Toid Amuda's profile. Mr. Toid Amuda is the founder and managing partner at Lawvocate Attorneys, a firm of lawyers, investment consultants, and arbitrators. He is an international commercial dispute attorney and an investment consultant. He has significant experience in commercial litigation, commercial arbitration, investment treaty arbitration. He holds a Master's of Law degree with distinctions in international business law from the University of Law in London, United Kingdom. He has written a significant number of articles in the dispute resolution space and holds several awards. His experience is multi-jurisdictional. In his role as an investment consultant, he regularly assists business in raising capital for their expansion, ranging from private equities to venture capital. Like I said, Mr. Amuda is someone that is vastly experienced in this field, and we are happy and lucky to have him as a mentor in this quarter. So hopefully, when he joins us, he will be giving us some feedback as to today's class. Second mentor we're expecting in today's class is Mr. Joseph Saidon. Mr. Joseph is a team lead at Shrem and Blank's partner. He leads the firm Arbitration, Maritime, Construction, and Energy Disputes Practice Group. He is a graduate of law from the Niger Delta University and the Nigerian Law School. Joseph has extensive experience in arbitration on commercial litigation. He has acted as counsel in several international arbitration and arbitrary award enforcement proceedings under major arbitration rules, including ICC, DIAC, Unitral, MAAN, and RCICAL. His focus is on providing cutting-edge strategies to resolve disputes in the areas of maritime, oil and gas, commercial contracts, construction, corporate debt recovery, bankruptcy / insolvency, and civil fraud / white collar crimes. He is also experienced in advising clients in relation to concession contracts, joint venture agreements, maritime assets acquisition, due diligence, and distress situations. Thank you so much, Mr. Joseph. It's always a pleasure having you around. I'm not sure he's here with us, but we look forward to having him in class. So thirdly, we're expecting Miss Fra Awasum. Miss Pa Fra Awasum is a distinguished Cameroon professional specialized in international arbitration, mediation, and consultancy, with an extensive academic background that includes an LLM, MSc, and an ongoing PhD studies. She is a recognized expert in her field. Ms. Pa holds several prestigious qualifications, including membership in the Chartered Institute of Arbitrators, a fellow at the International Mediation Campus, Germany, and ICCYAA member. In recognition to her contribution, Ms. Pa was named one of the 50 power people in Africa by the ULOY Foundation and the African Women's CEO Network in 2024. She is also a seasoned public speaker, regularly sharing her expertise at national and international conferences on topics such as business strategy, gender equality, and environmental sustainability. Ms. Pa's extensive certification and training further underscores her commitment to professional excellency and her role as a leading advocate for justice, peace, and development in Africa. Thank you so much, Ms. Pa. You have been of great invaluable contribution to our mentorship program, and we are always happy to have you around. Fourthly, if for today we'll be having Miss Natalia, or we're expecting to have Miss Natalia Odidika Esi Zobe. Sorry for the way I pronounce that name. If she's on call, please, she can kindly help me with the correct pronunciation. Miss Natalia is an accomplished legal practitioner, accredited mediator speaker, trainer, and author of the book 7 Steps to Handle Depression. That many don't know. She is a founder and principal partner at Activity Attorneys, a legal practice that specializes in mediation and advocacy service. Natalia is also the creator and host of a weekly live program on Facebook called Legal Moments with Nat, where she offers free legal guidance to participants. Natalia is highly regarded for her expertise in dispute resolution and is a mentor of mediation, of two mediators undergoing mentorship program at the Lagos Multi-Door Courthouse. She also guides law students from various universities across Africa, Asia, and Europe. Natalia has served as an expert assessor and judge in numerous virtual mediation and negotiation competitions, both locally and internationally. She has several local and international certifications that backs her extensive experience in dispute resolution. Natalia is an active member of several prestigious professional organizations, including the Nigerian Bar Association, the Bar Session on Business Law, the Employment and Labor Law Association of Nigeria, and the um, National Association of Catholic Lawyers, Lagos Archdiocese. She currently serves as the Assistant Secretary for the Employment, Labor and Industry Relations Committee at the MBA session on Business Law and is a committee member on the MBA Lagos branch Continuous Legal Education. Natalia is also a member of the recruitment committee of the Employment of Labor Lawyers Association of Nigeria and a trained mediator on the panel of neutrals of organizations such as the Lagos Multi-Door Courthouse and the Nigerian Chambers of Commerce Dispute Resolution Center. In addition to her legal practice, Natalia is passionate about peace and advocacy and has been trained and appointed as a South Seoul HWPL Peace Educator / Ambassador within the African region. Natalia is fluent in multiple languages, including Igbo, English, and Yoruba, and has a basic understanding of Hausa and sign language. Besides Besides her professional endeavors, she has diverse interests, including speaking engagements, training facilitation, coaching, traveling, moderating events, running marathons, singing, and playing football. To reach Natalia, you can you can email her at natalia.odidika@gmail.com or visit her LinkedIn page on that's the URL to our LinkedIn page. Please do well to follow Miss Natalia as much as you can. She was here with us in the last quarter. I think this is the first time we're expecting her in class. I hope she's able to join us. It will be nice hearing from her vast wealth of experience and insights. Thirdly, we'll be expecting in class Mr. Samuel Orobosa Osarere. Mr. Samuel Orobosa Osarere is a mediator, an arbitrator, a peace advocate, a negotiator, and a distinguished ADR practitioner to the core. He possesses advanced knowledge and understanding in peace and conflict advocacy, community mediation, family mediation, workplace conflict management and resolution, peace building, amongst others. He is a minister of God that holds a PhD in theology from the Redeemed Christian Bible College, a graduate of the Word of Faith Bible Institute in the Living Faith Church, and a lover of peace and of the youths. He has also consulted for GIZ on strengthening the system for dispute resolution in markets. He has attended several training and hosted several seminars. He has modern technology as his toolkits with proficiency in computer usage. He has great passion for capacity building and research, and he is married to a beautiful wife and blessed with children. Thank you so much, Mr. Samuel, for always being with us. We are always, once and again, happy to have you in session. Last but not least, is the one and only Mr. Nachan Namwan. Mr. Nachan Namwan, who happens to also be the executive director of the Settlement House ADR Training Institute, the institute that JIIPCC is collaborating with to bring exclusively this mentorship program to you. So Mr. Nacham Namwan is a lawyer and the principal partner of the firm N. Nyacham & Co., a law firm based in Kaduna, Nigeria. He's a certified teacher, trainer, and facilitator. He's a faculty member and the executive director of the Settlement House ADR Training Institute, an institute for training, certification, and practice of alternative dispute resolution. He is also a member as well as a faculty member of the Nigerian Institute of Chartered Arbitrator, a model arbitration certification training institute in Nigeria. He is a facilitator for the Professional Diploma for the Professional Diploma in Education of Institutes of Education, Ahmadu Bello University, as well as an external facilitator with the Federal Polytechnic Kaduna. He's married to a female wife and blessed with 2 children. Thank you so much, Mr. Nachan, for everything that you do for us. You're welcome to class. I can see you're already here with us. You're welcome very much, sir. So not to waste any further time, I think we've spent quite a while. Sorry, we spent quite a while reading through mentors' profiles and welcoming you to today's class. So we will not want to waste any further time and we want to go straight into the session. Because of the peculiar nature of today's class, what we'll be doing first is, rather than hearing from our mentors, we'll be taking the practical simulations first. So based off of what we have for the two groups, group 3 and group 4, right, they were given the same case studies upon which they are supposed to conduct a practical mediation, a form of simulation mediation, right? And we sent out early last week. I think last week we sent out narration of the rules. We sent out a file that contains the storyline, the particular case and storyline, right? And they had to build up on that and carry out a simulation. So we'll be taking the simulation for group 3 and then we'll move on to group 4. And I am hopeful that both group 3 and group 4 are totally ready for today's class, right? So please do not waste any time. Group 3 and group 4, I'm sure you have your representatives on ground, right? You have your representatives on ground and you're ready for your simulation, right? So not to waste any time, group 3, if you're ready, please, you have 10 minutes for your simulation on the case that was sent to you. Kindly unmute, that is the members that are supposed to participate in this simulation should kindly unmute and start your simulation.
Hello, good evening, sir.
Yes, good evening.
Okay, I'm from group 3 and I'll be representing the mediator.
All right. So do we have the other members of your group on call?
Sorry, those who are going to be doing practicals, we need them to put on their video, and then they should be pinned so that we will see them. You understand? Or spotlight them so that we will see all of them. They have to put on their cameras, their video.
All right, so you've heard from Mr. Nyacham, right? So please, you can kindly turn on your video. I'll do how to pin those who are participating in the simulation. So please kindly turn on your videos and go ahead and start your simulation.
Okay. How do I pin the people?
All right, can you hear me, Opeyemi?
I can.
Sorry.
I can.
All right. So what I said was that you guys should introduce yourself, right? And
Okay.
the roles you could be playing, and then you guys can go ahead and start.
All right. Good evening, everyone. My name is Okuluwa I will be representing the mediator for this for the case at hand, the issue at hand. Thank you very much.
All right, thank you so much, Opeoluwa. So who do we have next for group 3?
Okay, good evening, everyone. My name is Oyinfemi Rafiat. I'll be the legal representative for group company A and B.
All right, thank you so much. Sorry, sorry, your name is just casting my mouth.
Just call me, yes, Rafiat.
Okay, Rafiat. Okay, thank you, Rafiat. All right, so who else do we have? Who is going to be representing Mr. Musa?
Okay. Good evening.
Yes.
So for me here, it's already 9. I think it's already 9 p.m. So it's already dark. Unfortunately,
Yes.
unless if I move right. Okay. Yes. So I'll be the one representing one of the disputant, Mr. Musa.
All right. Thank you so much, Mr. Musonda. All right. So we have 3 participants. Do we have any other person?
No, we don't.
All right. So please, you can go ahead and carry on.
All right, thank you very much. Good day. I would like to welcome the both parties to this mediation session. My name is Oluwashiku Opoluwa. I would also like to appreciate the both parties for appointing me as an expert mediator and a certified mediator from the Settlement House AD Training Institute for this session. The parties are free to refer to me by Ms. Opoluwa or Ms. Okwe, as I would like to create a very formal atmosphere that is free from any tension of any kind for this mediation session. Sorry?
All right. Please, the rest can go ahead. You can carry on.
Okay. So I would like for the parties on ground to please introduce themselves.
Okay, my name is Rafiat. Do you want to go first or I should go first?
You can go first.
Okay, thank you. My name is Rafiat Oyinfemi. I will be representing the A and B company in the issue between Mr. Musa and the company today. I want to thank Miss Opoluwa for being the mediator for this session. Thank you very much.
Thank you.
Okay. Greetings once more. So my name is Sandam Naito, and I'll be acting as Musa of the disputant. Thank you.
Thank you very much, Ms. Rafiat and Mr. Musa. Moving on, I would briefly like to mention the ground rules that will apply in the course of this mediation. First of all, I'd like for all mobile phones to be switched off to ensure that there's no distractions or distraction whatsoever. And I'll implore that everyone uses respectful languages. No vulgar languages will be condoned in this mediation session. Every party is to treat each other respectfully, and each party will be given the opportunity to express themselves and air their views. So before we begin proper, I would like to clarify from the counsel of A and B whether she has the authority and the power to take decisions on behalf of the company.
Yes, as the legal representative, I do have the power to make decisions for the company, which I think is best.
Okay, thank you very much, Ms. Rafiat. So I would, as a mediator in this current issue, my duty to mention my role and to explain the entire procedures of this mediation. And one of the things I'll be doing is to be facilitating this communication, asking questions to seek clarification, promote understanding, and to enable the party reach a consensus. So it must be noticed that the parties in this session will not be forced to agree to any settlement in we do not agree, they are not comfortable with. I mean, the session is going to proceed with the opening statement by the parties. And on that basis, I, your mediator, will set the agenda for the session. Okay, after setting the agenda, I would like for the parties to either remove or add anything to the agenda as they want, and I'll be obliged to do so. Okay, to start off, there will be a joint discussion where I'll ask few questions regarding what the parties say in the opening statement. And because of the discussion, if the parties comes to a deadlock, I'll have to call a private caucus where I'll have a private meeting with each parties to come to a consensus. And after this private caucus, we'll go on to the negotiations and come to a full agreement. So are the parties clear with the ground rules and all I've stated?
Yes.
Yes, very clear.
All right, so I would like to request that the legal counsel for A and B company begin with her opening statement. So in your own words, what is this bit about and how it affected the company, and the idea you think you want to give to resolve the issue?
Okay. Hello, everybody. Thank you, Ms. Okoyemi, for this session. Okay, I would like to say that Mr. Musa was given the job on the 21st of March 2020, and when he was given the job, he signed his contract with us to work. However, on the 28th of March, he sent the message, he called actually, he notified the company that there will be a state of emergency in the state he stays, that's Kaduna. And when he notified the company, he got across to the general manager who told him that he would be allowed to work from home, remote work, in which he would be paid as long as the work is done. However, for the past 8 months, he hasn't called or done any work, so he has not been paid. It has come to our notice that he had a relationship with the HR, therefore, she did not fire him and also did not get across to him, contrary to what was told to him by the general manager. He is requesting to be paid the salary for the 8 months he did not work and 20 million naira for damages. However, the company stands on the point that he would not be paid, not for the days he has not worked or for the months he has not worked, and he would not be paid for the damages because there's no record that he worked with us, nor did we have any idea about anything that went on between he and the HR manager.
All right, thank you very much, Ms. Rafias. Thank you for that explanation. Okay, I would like to also request Mr. Musa to briefly explain in your own word what the dispute is all about, how it has affected you, and what you like to, decisions you like to take to ensure the dispute is being resolved.
Thank you so much, Madam Okewa, for this opportunity. So, as it has been stated by the legal counsel, first, I actually moved from Abuja, where I used to work, and I used to be paid 200,000 naira. So when this job was advertised, I think they offered better. That was 250,000 naira. So I opted to apply for this job, and my application was successful. And then I was required. That was in May. That was in March 2020 to submit my documentations. That's how I submitted, and I
Musonda, are you with us? We can't hear you.
Tamusa,
I think,
Sorry, I think it was the network that had cut.
all right, please, you
May I
can carry on.
continue?
Yes, you can carry on.
Yes, so I was offered the job and I started working. And then when I got to this company, I discovered that my old friend, Miss Adamu, she was the HR, the human resource manager for A&B Company Limited. So because it's been long since I saw her, she was so glad to see me. And unfortunately, I had an encounter with her. And then when I went home, I just regretted what happened between me and her. I called her to say uh, everything that happened on that particular night, me and her. I didn't plan for it because I am a married man. So upon telling her that, she got upset and she promised that she was very determined that she was going to destroy my job, that she was going to destroy my life, that she was going to make sure that I was chucked out of the company. Yes, that is what she had promised. So in the same year 2020, there was an outbreak of COVID-19, and unfortunately, there was a lockdown. The government had actually declared a lockdown, and unfortunately, we had to close down. But then when I approached the general manager, he directed me to the HR, who is Miss Adam herself, to say she was going to give me the instructions on how I was going to continue working remotely at the comfort of my home. So then I proceeded and I actually communicated with Ms. Adamu, but however, she never gave me any proper response. So I was actually under the impression that the company had closed down, and so there was no work at all. Meanwhile, I was just deceived by Ms. Adam just because she had a grudge on me. So as a result, I stayed 8 months without getting paid, and as a result, I have accrued rentals at my apartment. My children, they need school fees. We are hungry. We don't have enough food. So I have been terribly affected by the negligence and malicious decision by the HR, the human resource manager for A and B company. So now, in this mediation, my hope is I should be I should get paid. I want at the end to be paid my salaries for 8 months, the 8 months that I was supposed to be paid for. Yes, and then also I'm also seeking damages for 2 million for the damage, the injuries, and the suffering that I've suffered because I've been distressed and my mental health is not okay due to what actually transpired. Thank you.
all right, thank you very much, Mr. Musa. Based on what everyone has said, I think we just have one agenda on ground, and which is whether Mr. Musa would be paid the 8 month arrears of 2 million naira salary and the damages of 20 million is asking. Are the parties okay with that?
Yes.
All right. Just for clarification's sake, I would love to ask the counsel for A and B if there was any measure that was taken to check, or any measure that was taken to examine whether enough procedures were being followed to ensure Mr. Musa's case was not different from every other employee. Any measure that was taken to check he was not rated in any form. Was any measures taken by the company?
He did call the company, he called the general manager to tell him about the situation that was going on in Kaduna. Take to note that Mr. Musa is not the only employee of the company that works in Kaduna, and the other workers were also notified that they will be working remotely and they would be paid, which actually happened. The company had no idea of the relationship going on between Mr. Musa and the HR manager, Mrs. Adam. Therefore, I think it is necessary to question Mr. Musa if he made any attempt to notify the company that though he was told a call would be given to him or a call would be made to him by the HR manager, knowing that she had sworn to make sure that his life would be chaotic, did he tell anybody in the company? Did he call the general manager who he called before to tell him about the new situation that he has not been called? However, why did he wait for 8 months, the period of 8 months to go before he brings this up? I think that's the only thing that should be questionable right now.
Okay, thank you, Ms. Raphael. I think this is the right moment to call a private caucus. So I would like to request that Mr. Musa please leave the session so I can proceed with a private caucus session with the legal counsel for A and B company.
Sure,
All right.
madam.
Before we begin this private caucus, Ms. Rockford, I would like to pose a question on how you think the session has been going so far, and is there anything you'd like to add or any ideas you have to add to ensure that this agreement becomes successful at the end and will come to a final negotiation?
I think the session has been going great so far, and I also want to reiterate the fact that the company is under no obligation to pay him any amount of money because he did not work at all. For the 8 months that he's claiming for, he did not work, so no work, no pay, and he shouldn't claim any damages of 20 million naira, basically because his relationship with the HR manager was not disclosed. It was illicit, it was wrong, and the company had no idea about it. But we will also take into consideration that the HR manager is a member of the company and she speaks on behalf of the company, and the issue communicated to Mr. Musa comes from her, therefore with the representation of the company. With that belief, we would only like to pay the partial amount of his entire 8 months. We will pay him the salary of 4 months. That is 1 million naira with no extra amount of damages or anything. That's the only offer we have for you.
All right. Thank you very much, Ms. Rafiat. Would you like me to disclose this to the other party?
Yes, I would like that. Thank you.
Okay, thank you very much. I would now request that you leave this session so that I can have them to proceed with the other session, private caucus with Mr. Musa. Mr. Musa,
Yes, yes. I mean,
hello, Mr. Musa.
oh, yes, yes, please. I mean, now.
Okay, thank you very much. So, Mr. Musa, I need you to know that whatever you say here is confidential and I can only disclose it to the other party unless you give me the authorization to. So before we start the session, I would like you to tell me how the session has been going thus far, and if you come up with any idea that will ensure that this mediation session ends successfully and will reach a very good consensus.
Okay. Yes, the session has just been great, and I've actually heard what the company has to say. Yes, but like I said before, I need to be paid my money back because, like I said, I have incurred a lot of expenses and liabilities, and I have suffered as a result. And by the way, whatever that happened was done by an employee of the company. So everything that is done by an employee, and for that matter, a human resource manager, this is the person who is in management. So whatever she did, I consider it to be an act of the company. And so the company should pay me what is due to me. Thank you.
Okay, thank you, Mr. Musa. So I'm saying this because I've been given authorization by Ms. Rothfeld, the legal practitioner for A and B company. So they have requested me to disclose this proposal, and they're offering to pay you a total amount of 1 million naira as partial payment for the 8 months that you did not work. And that's the only amount they are willing to offer. Do you consent to this proposal or not, Mr. Musa?
Um, okay, considering the fact that I did not work for the 8 months due to miscommunication by the miscommunication by Madam Adamu, I would accept the offer. But however, I think that is not actually enough. What is the fate of my employment with them? Because currently I'm jobless. I need to get back into that company and continue working. Yes, so that would be my counter offer. I can only accept their offer of partial payment until they also accept my offer of me to be retained in the employment. Yes.
Can you hear me? Can you hear me?
Yes, yes, I can hear you.
All right, I will relay your message, Mr. Musa, to the legal practitioner for A&B company. We will resume the joint session now. I'd like to call and request that the legal practitioner for A&B company come join us.
Okay.
Mr. Musa, do I have your consent to disclose all we've discussed? Mr. Musa. All right, thank you very much, Mr. Musa. Okay, I welcome all the parties. We've had a very fruitful caucus session. And since both parties have asked me to disclose whatever has been discussed from the caucus meeting, I will sum it up as this. So the legal practitioner for A&B company is willing to pay the amount of 1 million naira. They propose to pay the amount of 1 million naira as part payment for the 8 months to compensate and also to, considering the lockdown circumstances and to cover up of the expenses. Mr. Musa is a family man. They are willing to pay 1 million naira to Mr. Musa, and the consent, okay, and Mr. Musa has also consented to this proposal. However, I would like to ask the legal practitioner for A&B company to kindly tell us how the employment status of Mr. Musa is, whether he will still be retained in the company or he would not. Mr. Musa would like to know that.
Yes, sure. Mr. Musa will be retained in the company mainly because we also have to go through the issue that happened between Mr. Musa and the HR manager. But yes, he's still employed with our company.
All right, thank you very much, Ms. Ruffat. So saying that we have reached an agreement, I would like to read out what has been decided so that each party can both agree to it. So from the issues and the discussions that have been on, Ms. The noise is not
Hello.
coming from my hand. The noise is not
Yes,
from
but
my end.
yeah, sorry, you were muted by accident. So please carry. We weren't hearing you anymore. So please carry continue.
Okay. So I said, saying we've reached an agreement, I would like to read out the summary of the agreement so that both parties will agree to it. So from the decisions, from the discussions we've had, the legal practitioner of A&B company has proposed to pay a sum of 1 million naira to Mr. Musa, considering the lockdown circumstances and all that has been said. And Mr. Musa has agreed to accept this sum from the company. The company has also agreed that they would retain Mr. Musa his employment status will still be valid in the company, and he'll be allowed to work from now henceforth with pay. Do the parties agree with this summary I've read?
Yes.
Mr. Musa?
Yes, yes, I agree.
Okay, thank you very much. Now I would request that both parties give their closing statements. Mr. Musa, you can go on.
Okay, thank you very much. I'm so grateful that this mediation session has been very fruitful, and I have been I've been able to be granted what I was actually searching for, and I would say it's a win-win situation. Yes, so I would like just to thank the mediator for this wonderful work. Yes, otherwise I'm so grateful for everything. Thank you so much.
Thank you very much, Mr. Musa. Ms. Rafiat, your closing statement.
I would like to thank Ms. Ope for handling this session well. It was a really fruitful session. I'm happy that we've been able to come to a balanced agreement where Mr. Musa has to come back to work with us. Thank you very much for this opportunity.
Thank you very much, Ms. Rafiat. So based on the decision of today, I will be pleading an agreement. So everything that has been decided today will be formally documented and shall be signed by both parties, and this will be binding upon them. Thank you everyone for your time. We've come to the end of this mediation session. It has been a very wonderful session, and I wish all the parties the very best in future. Thank you.
Thank you very much.
All right, thank you very much to the members of Group 3 for putting together that simulation. I say well done to you and to everyone that took out their time to watch videos online to ensure that you people were able to put that together. Well done. Thank you very much. So before we move on to Group 4, right, please, I would like for us to kindly take a quick screenshot, a quick picture. Right, my own location is very dark and the lights here just went off. So please, I would like to ask if it's possible, can we turn on our video so that we can take a quick screenshot and move on with the rest of the class. So please kindly turn on your videos. Right, thank you very much. Thank you very much, Opeoluwa. Thank you very much, Mary. Yes, I can see quite a number of people turning on their videos. So well done. We'll be doing that in a few minutes. So okay, please just one more. We'll be taking one more. Sorry about that. All right, thank you very much. Sorry it took quite a while. Right, so thank you so much for complying. So well done again to Group 3 for putting together that simulation. So please, can we have Group 4? If that will be possible, can we have Group 4 start their simulation like Group 3 did? Please turn on your videos so that we can go ahead and start. Members of Group 4, do we have members of Group 4 in class? Do we have members of Group 4 in class? Do we have members of Group 4 in class? Okay. I don't know. Where, please, if you are in group 4, please can you kindly indicate? Please, do we have members of group 4 on call? Okay, it seems we don't have any group 4 member on call, right? Which is very surprising. I don't know why group we don't have that. I hope this is not, well, it's all good. Moving forward, right? Once again, well done to group 3 for putting together that simulation. Mr. Nyacham, please, we would like to hand over to you. You've watched the simulation session from group 3, what they put together and how they went around it. So sir, please, we just want you to give a feedback to what they've done so that they can know where they made peculiar mistakes, what they need to do better, and is there something about the session that they did not get right? So sir, we would like to hand over to you. Mr. Nyacham, are you with us? Okay, it seems Mr. Nyacham is not on call. All right, so we'll just be waiting a bit for Mr. Nyacham to join in back into the session. I'm sure it was a little network issue he had from his end. But then moving forward, right, we'll just like to discuss about group participation within sessions. So please, if at all your group, if at all you've been assigned to a particular role for the week, or your group has been assigned to a particular role for the week, if there are going to be peculiar issues or reasons why your group will not be able to carry out that particular role or task, you should kindly reach out. Sorry, you guys should kindly reach out to me. As early as I think Friday, we had sent these roles to you guys, and we expected that it should have not necessarily been difficult putting together a team that can carry out the mediation on behalf of your group. So moving or in consideration of the next class, right? That is week 4, where we'll be having arbitration and mediation simulation. We would want to ask that please group 1 and group 2, because you people will be responsible for taking over the arbitration simulation. Kindly do well to ensure that you guys are coordinated enough to carry out your simulation in class. So please kindly give me a few minutes to reach out to Mr. Nyacham. All right. Thank you. Okay, I can see Mr. Nyacham is back with us. You're welcome back, sir. Thank you so much for rejoining the session. So please, I'm sure you were on call when the group 3 took part in their, or group 3 conducted their simulation. So please, I would like for you to give feedback to their simulation, where you feel like they didn't do so well, or things that they should have paid attention to that they did not, and what advice you generally have for them, sir?
What happened to the other group?
Sir, we don't seem to have any member of that group on call.
Wow.
Yes, sir. So, but we'll be dealing with that, sir. I'll be dealing with that after the session, sir.
Okay. Okay. All right. So okay. I've watched the discussion, the process. It was actually very interesting. So I want to start by appreciating Group 3 for that wonderful presentation. I can see that they took time to prepare, and that's very, very encouraging to see that what we have not, it's encouraging to see that the efforts we have made or put on was actually valuable, and they did some practical, and for them to see how it all, to see it on the practical and how it is or how it ought to be. That's very, very good. I want to appreciate the mediator for a job well done, as well as the parties, Mr. Musa, and I want to appreciate them especially. I think they have done a wonderful job. So yeah. So wait for mommy will soon be with you. Okay, so for the group, having established the fact that they have done wonderfully well, and that's only because they have actually taken time to prepare, So all right, so here we are. Group. Please, I think if you are not speaking, please mute yourself. So as we have stated generally they have done well, and that's because they have practiced, they have done what they are supposed to do. So I appreciate all of them for the effort and the time they have put in. Aside from that, we have told you about, we have spoken to you about the processes and stages of mediation. You have the processes and stages. Number one is that you have preparation. You do the necessary preparation, and then which is let's say that is joined with your opening stage. At the opening stage, preparation, everything has been done. You are now at the mediation table. You express, you state your own side of the story. That's opening statement, right? So, uh, so the opening stage, and then you have the next stage is where you do your you set your agenda, and then you do your discussion, your proposal, and then you go to the next stage, the beginning stage, and then you get to the closing stage. Now, if you look at what they have done, I see that the mediator, Opeoluwa Fisayomi, she has done well. She has actually expressed, she started well. That's for the mediator. She gave an opening statement. So she started by giving her own opening statement, and the opening statement, usually the opening statement is supposed to contain introduction about herself, how the parties needs to be addressed. So I think one of the things that is they've not done is the mediator. First of all, I saw that the mediator appreciates the parties for choosing mediation and then introduce herself. So you tell them, my name is so person, and this is how I want to be called. You can call me Miss Mediator or Mr. Mediator or Mr. Nanchan or something. Then the parties introduce themselves, and they will tell the mediator how they would want to be addressed. That's very, very important, how they want to be addressed. So if they say, okay, in this case now, I saw that she actually confirmed if the party representing a company has a letter authority. So you have to find out whether there is really a letter of authority or not. So if they say, okay, I have authority, so you have to see the letter of authority, so that you will not, at the end of it, discover that somebody say he has authority, but he, in the real sense, does not have that authority. That's very, very important for us to consider. So if you have established the fact that this is what we are supposed to, this is how you should be addressed, then you can now go into the issue of opening statement. You go into opening statement. The opening statement is basically what the party, what a particular party wants, or his own side of the story. That is what the opening statement. So party A, most times you go for the party that brought the matter. The simple reason is he is the one that brought the matter, like Mr. Musa, who was the one that initiated the matter. So go first. That is what you tell them, so that they will understand the rationale or the reason behind saying, okay, this person should. I've done a mediation where I, as a party, I was like, why will you ask this other person to? Because the mediator says that he wants to start with, I brought the matter, and the mediator say he wants to start with the other side. So I say, why will you start with the other side when I am the one that actually said I had issue and I had to bring the matter to for mediation? Why will you want to go and start with the other person? So that will show an issue. It will indicate either a form of partiality, and unequal treatment, so to say. So you need to take note that when you have thanked the parties, you now do your own opening statement as the mediator. In the opening statement, that is where you want to help them to see that you are someone who has been trained and certified, and you have been practicing possibly for so number of years, and that you have done something of similar nature. See, that is your opening statement. Then your opening statement is the one that set the course for the mediation. Some people have not even been in a mediation session before. So since they have not been in a mediation session before, they may not know what it is. They will still be saying that we are in court, that they sent us to court, the alkali or the magistrate or the judge, because they don't know. So at your opening statement as the mediator, you want to find out from them whether they have been in a mediation session, and if they have not been in a mediation session, then you use your opening statement to explain to them. Mediation is simply a negotiation that is assisted by a third party neutral, which is myself being appointed. I am there not to decide for you, but to assist you to discuss and guide you on how you can reach an amicable resolution. That is what you are to do. That is what you are to explain to them. And then while doing this thing, you need them to know that the principles of voluntariness, confidentiality, without prejudice, commitment to the process, and discussions to be made frankly, because nothing that is going to be discussed there is going to be diverted. So you see, in the opening statement, she did not mention any of these things, so that the parties can be confident to see, if I say the truth here, later on, if we don't settle, they will now go and use it against me in court. No. Voluntariness, the parties have the right to withdraw at any time. It is party driven, and all of those things. You have to explain to them what is it, the principles of mediation: impartiality, voluntariness, decision making is of the parties, all of those things. You are supposed to make it very clear to the parties. That is setting the course. Then when it comes to the rule, I have had the mediator saying that this is the ground rules. She just set the ground rules for them and tells them that they should do like this, not do like this, do like this, not do like this. Now, it is good to actually collaboratively set the ground rules. So instead of saying that they are not supposed to do A, B, and C, you can decide to say, okay, now for us to have a fruitful conversation, we need to agree on, as as adults, agree as professionals, agree on how to go about these things. So we want it to move smoothly, so will it be okay if we say, for example, please don't be using your phone or answering calls, during the session, or put your phone on silent? Will that be okay with all of us? Is that, I say, oh yes, that is fine. So okay, now what about, so that we can have a good discussion? If one party is talking, will that be okay? Let the party finish talking. If the other person has anything to say, should not interrupt. You should just take note of it and write it down. Will that be okay? The party will say, oh, okay, that's fine. Okay. So you now say, okay, so we have agreed that this is what we are going to do. This is how we will go about it. So you see, that is good, isn't it? Your Excellency, sir, Ambassador Samuel, you are welcome. We're happy to have you.
Good evening, Your Highness. It's a pleasure to be here, sir.
Thank you very much, sir. So,
Apologies, I joined late. I just got home from service.
thank you for having you, sir. We appreciate your time. So, you see that oh, thank you very much, sir, for joining us. Okay, so
Thank you, sir.
now, yes. So you see, that is the process. If you want to set the rules during your opening statement, do it in a very collaborative way. Okay, this is the first time I'm seeing you without tie and suit.
I just got home from from service. I just remember that we're supposed to join in. Sorry, I joined late. I had to pull off everything.
Yeah, at least you are looking unofficial. You're always official.
It is
It's
well,
right.
sir. Good evening, everyone.
Good evening, yes, sir. So they did a practical. One group presented, so we are just trying to give feedback as to what they have done. They did well, actually. Just that one or two things. This is not a training, so to say. So I think based on the little we have taught you, you have done wonderfully well, and you need to be commended for it. It's just literally two corrections, and these are things that you can actually begin to practice, and eventually, if you have opportunity to get trained. I don't know how many of you took advantage of the settlement house training. We gave opportunities for some of you to take part. Uh, I don't know how many of you took part in the training and reach out. So, but when you go for a formal training, these things will be worked over, and then the concepts will not be strange for you. So instead of setting the standard and saying this is the rules and regulation, or this is the do's and don'ts, do it collaboratively in such a way that everybody will take responsibility for the decision you have jointly made. Instead of like, the mediator say we should not make call, we should not interrupt, we should not do this and that. It's the mediator's decision. It is not that of the parties. So in as much as you can say this is what we need to do, you need to take charge, do it in such a way that the parties can develop trust and confidence. The parties can still maintain and own the process, since we know that it is actually party driven. So when you tell them that, okay, I think it is good for us to talk very calmly, respectfully, and to avoid any form of use of abusive words. Is that okay? And then you see this one say, oh, of course, that's fine, that's fine. You see, you are getting them to agree instead of saying, this is what you want. That's the role of the mediator. The mediator may have something in mind that he wants the parties to do, but he may not come out expressly to say, but he wants it to be in such a way that that thing that is in his mind, he will find a way of making the parties get to know what is in his mind, adopt it as their own without expressly saying it. That is the skills you are acquiring. That is what you are developing. So take note. This feedback is for the mediator, so that those who have served as parties should also take note of it, so that when they have opportunity to serve as such, they know what they need to do. So another thing is they have confirmed that the parties have authority. And one thing you have not done as a mediator or that group is you want to confirm if the parties have signed the mediation agreement to mediate. Because you see, it is one thing for someone to say, okay, we are going for mediation or we are at the mediation table. It's one thing for the person to say it. And it's another thing. Who heard what I just said? Who can tell me what I just said? Efosa. What's the last thing I said?
Sir, I think you went silent for a second. We were listening, but then you went silent for a second.
And what was the last thing I said? What was the point I was talking about?
Yes, sir. You were talking about the role the mediator should take. You were saying how that the mediator should find a common ground upon which he can pass his idea without outrightly saying it. But then he gets the parties to acknowledge that that is the idea that is collaboratively shared by both parties, including that of the mediator.
Okay,
I
so
think
ensure that, yes.
you're saying something about the mediator ensuring that the mediation agreement has been signed, that two of them signed
Agreement
and
to mediate.
it's yes,
Agreement
sir.
to mediate, yes. Victor.
Yes,
Okay.
I was just going to say what exactly what Okpolua said. You said the mediator should make sure that the parties have signed the agreement to mediate, because it's possible for a party to be saying one thing and have actually done the negative. So it is possible the party is saying, okay, we want to mediate, but they have not really actually signed the agreement to mediate.
Thank you, Mr. Ambassador, sir. Would you like to tell us a bit about the relevance of an agreement to mediate before we proceed?
Okay, thank you for the opportunity. Please confirm if I'm audible. Can you hear me?
Ambassador, Ambassador, we can hear you with an ambassadorial voice, sir.
Oh, thank you so much. Let me just quickly appreciate everyone for making it a date with us. Thank you for the opportunity. Apologies, I joined late. Wednesdays happens to be my service days, and we have to close before I join in. The importance of mediation agreement is very keen, knowing fully well that the mediation process is, number one, party driven and is based on a consensus between both parties. And so we must begin emphasizing the need for parties to sign the mediation agreement. That gives us a green light to make progress. When parties do not sign the mediation agreement, it therefore means they are not ready to submit to the mediation. There are basically different documents they may wish to sign. They may wish to sign the mediation agreement, the confidentiality form, and that is a way of bringing both parties to understand that they are needed to make the process a success. Usually, how does the mediation agreement looks like? The format may differ from different institutes, but basically, you have the name of the service provider, the mediation house that is providing it. So if we are using Shati, we're going to have Shati logo and Shati name. Going to have the name of the claimant, taking into consideration if the claimant is an individual or if the claimant is an organization. The name will be there, the names of the parties representing. And usually we may have more than one persons as claimants or more than one persons as responded. Therefore means we may need to agree among the different persons that are the claimant, who will be the lead spokesperson. So if we need someone to make a position on behalf of the claimant, we should be able to identify who the lead spokesperson is for the claimant and who the lead spokesperson is for the respondent. Then there may be provision to accommodate any other person that may not be a direct party but will be of interest to the process, maybe in form of witness. So from the beginning, we have a clear understanding of all the persons that will be vital to the process. Then the venue that the session is going to be held and the signature of who is going to be the mediator. All this is a document. Once the parties sign the mediation agreement, it therefore means they are bound to go through the process. It is very ethical that no mediation session can begin formally when parties have not committed their signature to a mediation agreement. And quickly, let me also chip in. Most times, while we are trying to set the stage for the mediation to begin properly, parties that come to mediation may come with their lawyers, with their legal representatives, especially if the matters that were referred from the court. At the beginning, it is good we set the record straight by making parties understand their role and making the lawyers understand their role. In mediation session, we know it is party driven, party speaks. It doesn't mean that lawyers are not needed. It doesn't mean lawyers are not important. If the parties feel they can come to the session without their legal representatives, fine. But if they deem it fit to come with their lawyer, it therefore means we must help and assist the lawyers understand that for the mediation session, if you don't mind, we'll be needing your client to speak for himself. And if there's any need, you are needed to make an addition, we will allow you speak. Therefore, it means that in the sitting position, the parties sit closer to the mediator before the counsel. So the parties make response to questions that have been asked. Why, if the lawyers are needed, they can add their voice. And usually, we have mediators that will just tell parties, your lawyer is not supposed to be here. Lawyers are supposed to keep quiet in the mediation session. We have discovered that if we toe that line, we may put the session in jeopardy, because usually I've been in part of a session where the party will tell you, my lawyer said I should not come for the session, and that is why I'm not here, because they have faith in the lawyers. So you must work on them. That is why we need emotional intelligence to help them appreciate their role as coaches and not players. In a football field, you have coach. There's a time for the coach to do his job, and there's a time for players to do their job. Coaches are very vital. That's how legal practitioners are vital. But when it is time for the session properly, we allow parties speak, and there may be need for us to seek more information and insight from the lawyers that are in the session. So we must balance the equation and let everybody feel valuable in the process. And we should also understand that while we are trying to begin the mediation session, the issue of fees must be clearly sorted out. The fees to be paid for the mediation must be sorted out. As we all know, payment is made for a mediation session before the process officially begins, because we are not paying for the outcome. Payment is for the process. So whether parties settle or not, they ought to make payments. The amount to be paid, how is to be paid, and the proportion is to be paid. Ethically, it is 50-50, 50% to the claimant, 50% to the respondent. When you have one claimant and 4 respondents, it simply means that the one claimant takes care of the 50%, while the 4 respondents share the remaining 50% amongst themselves. We don't look at them based on their number, we look at them based on the side they belong to. Now, moving forward, we must also be able to understand the issue of language, balance the power. And I want to appreciate Mr. Nachang for taking pains to emphasize other areas in the mediation session. I hope I've been able to respond to the issues you needed me to respond to. Thank you so much, sir. I'm grateful.
Thank you very much, Ambassador Samuel, for that wonderful contribution. So now that is it on there. You need to ensure that the parties sign agreement to mediate, and then confidentiality agreement where yes, confidentiality agreement, so that parties can easily discuss freely. Parties will discuss freely without any fear that whatsoever they discuss or agree or whatsoever document they disclose during the mediation session may be used against them later on. So it's without prejudice. So the mediator's fees is contained, discussion frankly is contained, the issue of bindingness, you can state that the process is non-binding, but the outcome of the negotiation or the mediation is binding. And then exception to confidentiality, except the exception to the issue of confidentiality, you say, except for the purpose of enforcement, the discussion or whatsoever and the agreement is going to remain confidential between the parties without letting other people know about it. No, so you need to state that.
Can I quickly chip in something I just remembered, please?
Yes, sir.
Okay. We all know that every dispute is unique, as it were. They differ from one to the other. Now, there are some matters that it is so glaring that at the inception, based on your experience in mediation, you can have a meta forecast that at some point there will be the need to have a neutral fact finder, especially when both parties are giving you different account of a particular event, different summary of a particular object, maybe a building or a contract. The building is actually located in a place. So there may be the need for parties to engage the services of a neutral fact finder, a fact finder that is neutral. So it is also at the beginning, you may bring it to the attention of the parties that if at any point we need to engage the services of a neutral fact finder, a third party that would be needed to journey to a particular location and give us empirical facts on the true nature of the issue, we may need to do so. Or we may also let the parties know if we can infer that there may be need for what we call expert determination. Expert determination is a process that you submit the facts of the dispute to experts. They need to carry out a survey to ascertain the true nature of the fact. We may also expose the parties to this while we are beginning, because we may never know the tone or the line that the dispute may veer out to. The beauty of expert determination is maybe you want to do paternity issue, or you want to do forensic analysis, or whatever the case may be. It therefore means that when you get to a point and it is necessary to engage another expert, another professional to help you ascertain the true picture of the dispute, the parties must give their consent And for expert determination, it is very critical because the same way parties, please, if you're not on the call, let's be muted. If you're not on the call, please be muted. The same way parties sign the mediation agreement in the beginning of the mediation process, if it becomes necessary that we need to engage the services of a forensic expert, maybe you want to confirm if actually a document was signed by a particular person, if actually somebody wrote a particular, you want to be sure that this is exactly the signature or the writing, or you want to confirm paternity. We must understand that once any dispute goes to the stage of engaging an expert, the outcome from that expert determination is binding on both parties. It is not subject to any form of debate whatsoever. So when it is so glaring that the matter needs to be further analyzed by an expert, it therefore means subject to the suggestion and decision of the parties, they may need to do another undertaking approving that an expert be invited to carry out some further analysis on the matter, and they'll be binding to whatever the outcome is. And whatever the outcome is binding on the parties. If that is the sole area of dispute, it puts finality to the issue. But if there are other areas in the dispute, they can analyze the other areas based on consensus, while the other part that has been escalated for expert determination, whatever the verdict when it comes out, is binding on both parties. I'm sorry if it sounds so complex, but I'm sure as we make progress, we'll begin to understand and appreciate all this information that we are making available to you. Thank you so much. I appreciate your attention.
So, thank you, Ambassador Samuel, for that wonderful contribution. Now, Dennis, you need to take note. Those have not had sessions. I believe you have measures to ensure that they don't get any form of certificate, because the essence is you take part in all the sessions. You have about 70% attendance, and then you have participated in all the activities you have done, you've written your articles, among other things. So this thing is not for, this thing is not, it is not something that we should take lightly. If you know how much mediation trainings are, I believe that the participants will take it more serious. We have over 40 to 50% attending the session. We now have only about 20, and if you remove the facilitators, JIIPCC, and the mentors, how many people?
Okay, I think Mr. Nachang is having some network glitch. Okay, why we wait for him to join us back, I just want to quickly add that we all know that ADR services in general is time friendly. So while we are introducing parties to the mediation session, we must help them appreciate the fact that we don't take unnecessary adjournment. There are some multi-door court houses, they meet weekly. So if a session holds today, there's the likelihood that in the next 1 week or in the next fortnight, the other session will hold. So parties must understand that we don't take unnecessary adjournment. Unlike litigation that you can have 2 months or 3 months or 4 months, as the case may be, in mediation, the time gap, the time frame between one session and another session is very, very short. We appreciate hasty dispensation and attention given to the issues. I just needed to add that. Mr. Nachang, welcome back.
Okay, so thank you. What I was trying to say is that I just realized, Mr. Dennis, can you hear me? Mr. Dennis.
Yes, sir. I can hear you, sir.
Okay, so I just realized that sometimes some of the participants take this opportunity for granted, because I know we have over 40 to 50 participants. Now today we have just 20 persons minus the facilitators. We need to understand that for the fact that we are offering to give this training and mentorship session for free does not mean that we should abuse it. We some of us are deeply involved in ADR, and we know how expensive it is. But as our own way of adding value and giving to the society, creating the necessary awareness, we have decided to organize this mentorship so that everyone who is interested can actually take part. So, but a situation where you see someone who, in fact, a group completely did not present, they were not even available. I don't understand how to excuse or explain that kind of situation. You are not available and you are supposed to present. So we should not take certain things for granted. So we have to ensure that only those, even if you have indicated interest and make commitment for certificate, only those who have actually take part, and we can confirm from their attendance and everything, that will be issued certificates at the end of. Please let us be serious. Let us take advantage of the opportunity that has been given to us to add value to ourselves, to have a guidance as to the way and manner, maybe a guidance as to what area of practice we can go into if we're interested in the alternative dispute resolution. We don't need to take that thing for granted. So having said so, I was hoping that we're going to have over 40 to 50 people on this call, more so that this is practical. This is a practical aspect of all the stories and theories that we have been saying. So you present a practical session so that you have opportunity for people who have created their time and attention to listen to you. Like someone will come and sit down for like 2 hours, 1 hour, 30 minutes, 2 hours listening to you, just to be able to make impact. And then the people that are supposed to be impacted are not there, and they are given opportunity to do a practical and come the whole group, they are not available. That is really unacceptable, so to say, and I don't think it's appropriate in the circumstance. So please, let's take note of that. Now, having said so, we have emphasized the fact that there is need for parties to sign an agreement to mediate. And that is simple. That is their own submission. They have submitted to mediate, and they know the implication and the consequence, and that they are going to discuss openly, frankly, and they will be committed to the process. And then you avoid a situation where someone will come and tell you, I just came to listen. I'm just hearing, and now that I've heard, okay, I'm going to get back to my boss. I'm going to get back to the office or to the company. No, let's avoid that. Get the parties know what they are doing. Sign an agreement for confidentiality, which binds everybody. That agreement binds everybody, the mediator, the parties, their lawyers, and every other person who is at the mediation proceeding at the permission or with the consent of the parties. That's very important. Now, one other issue was the issue of setting agenda. I really appreciate the fact that the mediator was able to set an agenda and the agenda is that they are going to discuss the issue of the 8 months salary. That's a good one. What is the purpose of setting an agenda? Agenda is simply just like the agenda we used to know during meetings. It specifies what we are going to be discussing on. So, and those agenda are going to be made, you are going to decide on the agenda, opening statement of the parties. So when the parties finish opening their making their opening statement, you are not going to get to know that, okay, these are important issues. If, for example, it is a contract for the supply of rice, and you say, please supply 1 bag of rice, 2 bag of rice for me for a particular purpose, and that has not been supplied. So you will want to, okay, so on the when of both parties finish giving their statement, you want to be able to identify critical issues, and then if they say supply 2 bags of rice at 5,000 naira, and then you are paid the money, and the person did not supply. Now, when you are setting an agenda, the issue of there is a contract for the supply of 5 bags of rice at so amount of money on so date, all of those things may not be an issue because they should not form part of your agenda because it is not denied. But someone is saying that I gave 10,000 naira for the supply, you didn't supply. Because of that, I've incurred expenses, I've incurred damages, and I want you to return because I have to rush and get the rice somewhere, cook it at very expensive to spend a lot of money doing that type of thing. So I want you to refund the money I've given you with interest for what you have done. So you see, clearly you see that the issue of the refund can be an agenda of the amount I was given. And then another thing is the issue of the damage that you are claiming is going to be an agenda. Those issues that you know that they are contentious and need to be resolved for proper amicable resolution of the dispute, those are the things that you are going to put as an agenda. Now, in as much as the mediator can actually say this is what he feels the agenda should be, I always advocate that if it is possible, try as much as possible to collaboratively set an agenda. Now, if you just give them an agenda and then the parties are not willing to discuss it, you see, that's going to be an issue. So an agenda must be something that both parties are willing and ready to discuss. And by the time you discuss and you resolve it, that will lead favorably to the proper resolution of the matter. So let's take note. Agenda is very good. And one advantage of agenda is that it will guide your conversation. You move from one level to the other on issue of damages. You discuss it. This is what parties have agreed. On issue of refund, this is what they agreed. The person who received the money is ready to refund, but he said, please give me 1 month, and at that 1 month, I'm going to pay you 5,000 naira in the morning, and I will pay you 5,000 naira in the evening. You see, when you have an agenda, it helps you make your work easier. You just move from one place to another. But if you don't have any agenda, it means that you will just be discussing randomly without any form of guidance, and that will actually affect you. So that is one thing you should take note, and that's some of the things that I've jotted here. Now, I saw also that the mediator, it was so beautiful to see that the mediator actually made use of caucusing. Who is the mediator? Mrs. Ope Oluwa. Where is she? Opeoluwa. Where is Opeoluwa?
Please, do we still have the mediator, the person who did play the role of mediator with us? Okay, it seems she's no longer on call.
Okay. What of Oyen Pemi? Is it Oyen Pemi or Oyewumi?
Yes, Rodiat, she's on call.
Okay, let her put her camera on the person, the group, and then Mr.
Musonda. Yeah, so please, do we have Mr. Musonda with us and Rodiat?
Okay. So, okay, is she not around? Okay, she's not around. Okay, so now, you see, she made use of focusing. Mr. Samuel, will you want to just say one or two things shortly on the importance of focusing and when to go into focusing?
Okay, thank you so much. Caucusing is used when you have initially acquainted the parties that at some point in the mediation session, there'll be need for you to interface with either of the parties. You must have informed them earlier so that when it is needful for you to have it, it will not be scared, or they will not feel you are trying to sideline any of them. Caucusing simply means a confidential interaction between the mediator and either of the parties, where the party has freedom to speak to the mediator on some critical issues. Now, when you are in a session and you discover that you are not making headway concerning some matters, and you discover that beyond what has been presented by parties, there are some underlying issues that can add value to the process, and you need to confer, you need to make clarifications on some issues. You may need to appeal to one of the parties to excuse you. There's always a waiting room while you are not left alone with the other party to ask some questions to gain basic information. These questions that are being asked, you have already told the parties that no matter what they say in the mediation session, that it cannot be taken outside. So they are now free to air their minds. And whatever is being said to you in caucusing, you must take permission from the parties either to relate it to the other party or not. And even when you have permission to relate it to the other party, you must be sure that it must be relayed in a way, it must be communicated in a way that it will not cause any form of impediment in the mediation process. So we use caucusing for fact-finding purposes to find out more facts about the issues. We use caucusing when there's a stalemate in the mediation session, when it seems as if we have gotten to a brick wall and we are not making progress. We use caucusing when tension is being escalated. Usually these are disputants. There's a conflict between them. And when either party is speaking, tension may begin to rise. The atmosphere in the mediation room may no longer be cordial, may no longer be receptive, may no longer be mediation friendly or settlement friendly. At that point, there's the need to cause a break in transmission and allow one party excuse you so that you can meet with one of the parties, enable them douse their attention and help them realign their perception to the objective of the mediation session. So caucusing is being used based on need. But when you go with the textbook template, there are some trainings you will attend. You'll be told that immediately you've made your opening statement, you set the ground, you take parties into caucusing immediately. But we are of the opinion, I am of the opinion that caucusing is to be used when there's need for it. Because some parties that come to mediation already understand what mediation is all about. Some parties that come to mediation are fully aware of what they want. Some parties that come to mediation, they are matured and rational enough to understand that it is a give in and take. So they are already attuned to what it takes, especially parties that have undergone several mediation sessions before. So they understand what is at stake. They may just want to make progress and get a compromise, negotiate, and move on. We may have no need for caucusing at that level. But when you see that the parties before you are obstinate, there are some issues beyond what is written, beyond what the parties have said. There are other underlying issues. Or we have always said that a mediator needs to be very sensitive to what parties say and sensitive to what parties do not say, because there are verbal communications and non-verbal communications. I was opportune to be in a mediation session. There was a prof. The prof was a lady. The prof and her husband were on one side, and two young men were on the other side. It was a tenancy issue. They had rented one of the apartments to these young guys that were using for educational services. And while the prof was speaking, I discovered that all through her statement, the man didn't say anything. Her husband just did like this and put his head down. At some point, he was at some point he will now it became clearing that either the man does not support what the wife is saying, or beyond what the wife is saying, there are other things that have not been said. So at that point, it became very, very cautious for me to go into caucusing. And I had to excuse this other party and I focused with them. Now, when we are doing couple mediation, you must understand that you cannot evoke or invoke caucus without mutual approval from both of them. Because either of them may begin to ask, what is he saying to my wife? What is she saying to my wife? So at that point, I had to ask the man, sir, if you don't mind, is there anything you feel like adding to what your wife has said? Because you cannot tell him, is what your wife saying true? No. Is there anything you feel like adding to what your wife has said? Or is there anything she's saying that she's not saying well? And that was how we'll be able to get access to some very vital information that helped us to make progress in that session. So when it comes to coupled family mediation, you only use caucusing when it is extremely important, because you must understand that trust is of essence in couple mediation. But when you are dealing with parties, multi-parties, we use caucusing when there's a stalemate, when we are stuck, we cannot make progress. We use caucusing when tensions is high and you want to douse tension. You use caucusing when it is obvious there are some things that are being said. There's more to what is being said than what is being said. Thank you, thank you. And most times, when we want to get information from councils, we can do caucusing. We can excuse the parties and have the councils remaining in the hold and take information from them on how to move the process forward. So the more we gain experience, the more skillful we become in the use of caucusing. I hope I've been able to speak to the subject as you requested. Thank you for the opportunity.
All right. Thank you very much, Mr. Samuel, for that wonderful contribution. So as I conclude, now remember whatsoever you discuss in caucusing remains there. So the mediator actually made use of caucusing, and it was really it gladdens my heart that the ingredients of the processes and what needs to be done was actually followed. That's a good one. So it's good after conversation, let the other person know that whatsoever you discuss is confidential. And if you want to share the information, ask for permission, which the mediator did, and ask for permission. Now, one thing you should add is when party in the caucusing, don't just leave this party A. Don't leave party A one day these people are discussing there. Give them a little assignment. Please, will you ponder and think about how we can move this mediation forward and move what we are doing forward for us to have great success to achieve our purpose for today while I discuss with this person. So engage the person and give him something to be thinking about instead of just wondering, this is 5 minutes. See, the person will just be counting time and say, okay, you have discussed for 10 minutes here, and all of those things. So always party that will be waiting, so she has made use of focusing where necessary. So thank you very much. That's wonderful. You made use of focusing. And if you want to disclose any information from the focusing, ensure you take permission. But information you receive from caucusing and the party say, I don't want to devolve, I don't want to say it out. What you do is you keep it to yourself, but you use that knowledge as what you can use. Use that knowledge for what you have heard and known to be able to guide the parties. Let's say, for example, this one says, I'm willing to accept 10,000 instead of the 50,000 I'm asking for, but I don't want you to tell the other party, right? Then the other party say, the highest, if he likes, let him die. What we can give him is just 20,000 naira. You see, that is even far above what he's asking for. So if you go to tell the other party that this person has requested for 10,000, you see, you have cut short this one. So what you can do, you have the information, then you can start by saying, okay, based on our conversation and how far we have gone, now we are trying to look for a way forward. Mr. A, assuming Mr. A, just look at since we have established the fact that okay, there is need to pay something or give something, how much do you think it will be comfortable for you to give to party B? The person knows that you have had a conversation and you have mentioned, he has mentioned 20,000. So ask the person who has the money, they are both 20,000 to offer, and then he will say it in the presence of the other party. Then you ask the other party that he was willing to accept 10,000. So if he has more than that, that is an interesting thing, isn't it? So you turn to the other person knowing that you have discussed and 10,000 was okay. Now you have 20,000. You say, okay, is that the offer of 20,000 naira, would that be okay? Is that something you can accept? You say, you see that he may be smiling in his heart that God has buttered his bread, that kind of thing. So you have to be very strategic and the rest. So by the time you finish everything, one important thing that you look at is you close your deal, conclude it. Everything that you have agreed upon, if you have lawyers, let the lawyers help draft the processes, right? Let the lawyer help to draft the process. and document it so that parties will also, or without their legal representative, depending on the circumstances, and ensure that it is free from every form of ambiguity and everything is so. On a whole, I want to congratulate all of you, especially those who participated in the practical. It has actually been a wonderful session. So over to you, Mr. Samuel. If you have any last comment you want to give them, then we'll hand over to Mr. Dennis.
Not really. It's just to let them know that I appreciate all we are saying, assimilate them. It may not make so much sense now, but I'm sure at some point it will pop up. These words are just like seed. It will make sense on a very important day. Don't be discouraged. Keep at it. Be encouraged. Of everyone that actually registered for this mentorship program, I'm sure at the end of the day, only few may just make it. You see, many are called, but few are choosing. Determined to be among the few that will actually keep your passion alive, and it will be well. Thank you so much. Thank you to Shati and thank you to Gypsy for these opportunities. Apologies, like I said, Wednesdays is my service day, so I may be joining late, but it's always a pleasure interfacing with all of you. I appreciate you all.
Thank you very much, sir. Thank you. Mr. Dennis. Mr.
Hello, sir.
Dennis or Mr. Sophia. Sophia.
Yes, I can hear you.
Sophie.
Yes, I can hear you now, sir. All right. So, thank you to Mr. Samuel and thank you to Mr. Nyacham. For those who are still on call, right, I would like to kindly ask if we have any questions. Right, we've given the opportunities for the mentees to group treat. So, the mentors have also given feedback. They've addressed quite a number of things. Right. So, please, do we have questions? Do we have anyone with questions?
Yes, sir.
All right, go ahead, Mr. Victor. Mr. Victor, please, you can go ahead and ask your question.
Thank you so much. Yes, my question is about disclosure from the mediator. At what point does the mediator need to disclose maybe information about himself that may make the parties not to be comfortable with him carrying on with the mediation process? Thank you.
All right, sir. Mr. Nyacham, did you hear the question, sir?
Mr. Samuel, what?
All right. So, Mr. Samuel, please, sir, over to you, sir. We'd like to see if you can help with that question, sir.
Okay, let me be sure that we're on the same page. Let me confirm. The question is relating to at what point should the mediator disclose in a mediation session, right? If there's any relationship he has with any of the party. Is that your question?
Yes, sir.
Thank you so much. It goes to show that you actually understood when we were speaking to that particular point. Now, usually, the details of the disputants would have been communicated to the mediator before the session begins. They have done their filings, they've done their statement in issues and statement of responses. The names and background information would have been documented in a file, and the file must have been handed over to the mediator. In some instance, there's what we call pre-session. Pre-session is an initial interface between an assigned mediator and the parties. The the mediator that will be appointed to handle the dispute may still be the one that will handle the pre-session, or someone like a foreigner will be assigned to handle the pre-session and prepare the parties for the official session to begin with the assigned mediator. Whichever way, at the point the mediator gets the file and discover that this name, I think I know this name, I know this person, um, I'm attuned with this dispute. I don't think I can handle it. So the mediator can disclose to the ADR service provider, to the Mediation Institute, before meeting the parties physically. If the mediator is able to establish the fact that these are my family members, or this is my association member, or I'm aware of this dispute, or I'm even involved at some point in the dispute. So before meeting the parties, he can disclose and recluse himself. Or let's assume that on the day the sessions begin has been scheduled to begin, the mediator usually sits in while the parties are brought into the mediation room, and the parties are brought in at the same time, and they are made to sit down in different places. When the mediator sees the parties and is able to establish, wow, I think I know this party from somewhere, I know this other party from somewhere, it is his duty to officially inform the parties. If he knows the respondent, he should let the claimant understand the kind of relationship he has with the respondent and declare it publicly. Now, it is not just enough to declare it publicly. He can seek the consent of the claimant. I haven't told you that I know the respondent. Will you be comfortable that I proceed with this session? The claimant may say he doesn't mind. I think you can go ahead. So disclosure may be in different levels. Disclosure when the mediator knows, because of the relationship I have with this party, I cannot maintain impartiality. I want to recluse myself. Disclosure, after disclosing, knowing fully well that the relationship I have with this party will not in any way alter my position, but I need to get validity or confirmation from the other party if they are willing to allow me proceed. If the other party feels that you can proceed, fine. But if the other party kicks against it, you need to recluse yourself, because some relationship may be professional, some relationship may be personal. So it depends on the nature of the relationship, depend on the disposition of the mediator, whether he can waive the relationship aside and proceed. But ultimately, it depends on the decision of the other party. It is still possible that the mediator may have something in common with both parties. So these are the different scenarios that can relate to the issue of disclosure. But you must do your disclosure immediately you come in contact with the parties, either before meeting them, when you have seen the information and the background of the dispute to the Mediation Institute, or to the parties when the session is about to begin. I think I've been able to speak to the issues. Mr. Nathan, you can help fill in the gap. Thank you.
No, I think you have done justice to that. With this, I would just want to add that at the end of the mediation, they were called upon to give closing statement, closing. We don't have closing statement, so to say, in mediation. When you have reached your agreement, I think that is the end of it. So it is usually in arbitration that you have formal closing sessions. So where a statement where you summarize whatever that has happened, for the mediator, but for the arbitrator, we don't have such like that in mediation. So, Mr. Samuel, we have Mary and Mary. Please attend to their questions. They can go on ahead now.
All right, can you hear me now, sir?
We can
Yes,
hear you.
you're audible.
All right, thank you. I want to ask, is it necessary for the mediator always to opt to caucus session when he finds the fact of the case, or when he finds that all parties are able to communicate and all parties are willing to participate in a joint session? Thank you, sir.
Thank you, Jean Mary. It's always a delight hearing from you, and I must appreciate your commitment and consistency to ADR. Looking forward to have you making great impact in the space of ADR. Thank you so much. Now, while I was
You're
responding
welcome, sir.
to a question relating to this, I will respond from both sides. I and Prof. Natang, we were in a training where we were told that in all mediation sessions, you must make use of caucusing. And I am Prof. Nachangu of the school of thought that it is necessary, but it is not mandatory. And that is why the mediator is the driver of the process. Like I said, some text, some school of thought will tell you once you are done with your opening formalities and the fact of the case has been established, take the parties into caucusing, caucus with them and bring them back when there's need. But we are of the opinion that we make use of caucusing when it is necessary, because not to dispute is the same. In mediation, there's no precedence. In litigation, we have precedence. Every dispute differ, and the parties in each dispute differ. Some parties are ADR compliant. We have working matters. Working matters are complaints that are being brought to the attention of ADR practitioners by the people directly involved in the conflict. So I am of the opinion that we use caucusing when it is necessary. How do we know it is necessary? We have done cases where we resolve the matter at the first sitting. I've handled many cases. I'm sure Prof must have handled many cases to Prof Nachan. At the first sitting, the matters were resolved in less than 30 minutes because the parties had already made up their mind on they have understanding of what ADR is all about, and it was just very easy. Now, some people that come for mediation session, they've already agreed on how they want to settle. The essence of their coming is just to make sure that they can have a settlement agreement that can be processed to becoming a consent judgment. That is why they just came. Their position is already clearly spelled out. You don't need caucusing for such issues. But when we have issues that are virgin issues, and while you begin, it becomes obvious that, iceberg is unique because there's more to the iceberg than what is seen. That's how some issues are. What the parties are saying or what the parties stipulated in their documents, their statement of issues, as you make progress, it is obvious that there's a bigger picture. There are other underlying factors, or the dispute that they have may be the product of other unresolved disputes that is not a complex matter. There may be need for you to have a better understanding of that issue. To have a better understanding, you need to break into caucus with a particular party to understand better. You may choose to use caucus when you are making progress and it gets to a point you don't know what next to do. The progress has been stalled. There's breakage transmission. Everything looks as if it's at a brick wall. You may need to have a caucus to have a reflection. Now, you may also need to have caucus when it is obvious that tension is mounting, tension is increasing. You can sense that the atmosphere in the mediation room is no longer mediation savvy. There's a need to break that toxic air that is being generated. You may have to have caucusing so you can identify issues the way they are. You can also have caucusing when you are trying to clarify issues. So that is my view on the use of caucusing. It is important, but it is used when necessary. And at some point when you begin your career, you may not be too clear on how to use it. But as you continue, practice makes for perfection. As you continue having a relationship with mentors, understanding the process better, you will get better at what you do. Thank you so much. I hope my explanation is quite clear.
Thank you, sir. Always appreciate your deep explanation. Thank you.
Thank you, sir. Thank you, sir.
All
So
right.
can I take the last?
All right. Thank you so much, Mr. Samuel. Okay, we have one last person for questions. Mary, please, you can go ahead and ask your question.
Good evening, sir. Sir,
Hey,
I actually,
Mary.
uh, my initial question was, how is it possible for a mediation process to end in one day? But I think you touched on it like when you were explaining the question earlier. So now the question now is, how often, like, can a mediation process, like, during the course of like your career and your experience with ADR, like how often do you see mediation processes end in one day? Then I want to ask, what causes delay in mediation processes? And you mentioned you were saying something about like experts, to get like an expert. Is it I think expert witness? I'm sorry, I don't know why I was here. Like apart from that type of situation, what do you think, like in the course of your experience, causes like a lengthy or causes delay for parties, sorry, during the course of like a mediation process? Thank you.
Okay. While you were asking that question, I was trying to find a way to actually answer you in few words, because that question you just asked, especially the last question, is a whole training altogether. It's a whole training altogether. The first part of your question confirms that there are some sessions that can hold in one day. Depends on the number of the depends on the level of commitment the mediator and the parties have to invest in the process. A mediation session can last from 15 minutes, 20 minutes, 30 minutes to 4 hours, to 5 hours, to 6 hours. We have sat in a mediation session for 6 hours, 5 hours, 3 hours. You don't forget that it is not all about what the parties are saying, because what they are saying, parties speak from a point of understanding. Parties are positional in their interest from a point of understanding, from their conviction. So, what they are saying is based on what they have concluded in their mind. There's what they call consensus ad idem, the meeting of the mind. So, when you can assist a party have a mental reset, where you can assist a party to see something from a different perspective with a clearer understanding, it becomes inevitable for that party to have a change of mind. We have done matters where at the end of the session, one of the parties refunded to the other party the money they paid for the mediation session. A lot of things can happen. Humans are not as difficult as they appear to be, but we must understand that so many matters, not all matters are resolved. Some matters are fully resolved, Some matters are partially resolved. It means of all the issues brought to the mediation, some can be settled while others end being unresolved. It is still possible that none of the issues are resolved. We must understand that mediation is not a miracle center. So either way, the duration depends on the parties, the ability to properly prepare them to understand what mediation is all about. It is regrettable that many people come to mediation with the understanding of litigation. It cannot work. I hope I've been able to speak to that. Now, secondly, I I I, I want us to understand that there's what we call conflict resolution, and there's what we call conflict transformation. Conflict transformation is much more extensive than conflict resolution. Conflict resolution talks about the matter being solved, but let us be realistic. In essence, it is not all disputes that can be resolved. The best we can do is to manage because the damage has already been done. So we have conflict resolution, conflict management, and conflict transformation. So when we are talking about conflict transformation, we are simply saying the conflict is still there. The object of controversy is still very much alive, but the reaction of the parties to that issue changes. So where they still have the scar, but the pain that the scar produces has been taken off. So permit me to say it depends on what the mediator wants to achieve. If you want to achieve conflict resolution, conflict management, or conflict transformation usually takes a longer time, and we usually employ such skills when we are dealing with communal disputes, when we are dealing with family disputes. Yes, because the damage has been done. You cannot change the hand of the clock, but you can help parties see it from a different way. So where settlement is not possible, we are transforming them like a metamorphosis, giving them a new thinking about the issue, no longer seeing it from an adversary perspective, but appreciating it and moving ahead. So I hope I've been able to answer that question to the best of my knowledge. Hope you understood all I've said.
Yes, sir. Thank you very much, sir.
I appreciate you. I know Prof can assist to fill in the missing link. Prof Nachang, thank you so much. Over to you,
No,
sir.
I think you have done well. That is, I think that's all for today. Mr. Dennis.
All right, sir. Thank you so much, Mr. Nyacham, and thank you to Mr. Samuel, for helping run through questions. We sincerely do appreciate. In the light of everything that has been said today, and in the light of the simulation for this class, please, I would like to kindly encourage the mentees that are currently here. For next week, we'll be having arbitration simulation practicals. Right. So just the way we had for this week with group 3, please we'll be having for group 1 and group 2. Right. So I'll be sending instructions to the group as to how that should go. I would like to ask for maximum cooperation from all members of the group. Please and please, we want to have 2 groups present in the next class. Do well to comply. We are taking record and we are taking notes of your compliance to tasks that is being given during the sessions and after the sessions. So please kindly comply and always make sure to be in attendance in sessions. With this, we've come to the end of this class. I wish everyone a wonderful night's rest. Good night and enjoy the rest of your evening.
Thank you so much for the privilege.
Yes.
We are grateful.
Yes, and sorry, before we go, I would like to encourage our mentees to not to forget to post what they've learned in today's session kindly tag JIIPCC, kindly tag Shati House, Settlement House ADR Training Institute, and do not forget to share with your friends about the free clinic sessions that JIIPCC is holding. Thank you very much and good night.
To Professor Nachang, I salute you, sir. To JIIPCC, I salute you. To all participants, I salute you all. Thank you.
Thank you so much, Mr.
Thank you, sir.
Samuel.
Thank you, sir.